Breaking news. Welcome to today's headlines. Federal government react to Nnamdi Kanu's appeal court victory. Insist he still has cases to answer. Federal government reacts to Nnamdi Kanu's appeal court victory. Insist he still has cases to answer. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. Abubakar Malami, San. The Attorney General of the Federation, AGF, has reacted to Thursday's appeal court ruling that ordered the release of Nnamdi Kanu, the embattled leader of the proscribed indigenous people of Biafra, IPOB. Taking just hours to respond to the ruling, the AGF disclosed that the federal government will exploit all available options to determine the terrorism charge it preferred against Nnamdi Kanu. Recall that Nnamdi Kanu has been in the custody of the Department of State Services, DSS, since June 2021, when he was controversially extradited to Nigeria from Kenya. On Nnamdi Kanu's forced return to Nigeria, he was rearraigned on an amended 15-count charge. However, on April 8, the judge struck out 8 of the 15 counts in the charge. Further on in the legal tussle with the Nigerian government, Nnamdi Kanu, through his team of lawyers, led by Mike Ozekome, had filed an appeal marked CE ABJCR 625-2022, praying the court to quash the remaining 7 counts for being devoid of merit. The demand followed an earlier ruling of the trial judge, Binta Yakol of the Federal High Court in Abuja in April, dismissing 8 of the 15 amended counts filed against him by the federal government. Ozekome alleged that his client was forcefully abducted from Kenya and illegally brought back to the country. The senior lawyer argued that under the doctrine of speciality, as provided for in Section 15 of the Extradition Act, the federal government ought to have proceeded to try Kanu on the initial 5-count charge on which he was rearraigned before he fled the country. He argued that Kenya, being the country from where Kanu was arrested and extraordinarily renditioned to Nigeria, ought to have authorized his extradition and the new charges he is facing. Delivering judgment in the appeal on Thursday, a 3-member panel of the appellate court, led by Anotu Sankey, held that the federal government flouted the Terrorism Act and was also in violation of all known international conventions and treaties to which it is a signatory to guide in extradition process, thus breaching the right of the respondent. The court further held that having illegally and forcefully renditioned the appellant, the trial court is stripped of jurisdiction to continue to try Nnamdi Kanu. It held there was no denial by the Nigerian government lawyer, David Kaswe, in the appeal as to the submissions of Mike Ozakome. Nnamdi Kanu's counsel that the separatist leader was extraordinarily rendition from Kenya. The appellate court held that the failure of the federal government to adequately respond to Nnamdi Kanu's arguments gave merit to the appeal. It held that federal government was ominously silent on the issue, which it described as a very pivotal in determining whether the trial court would still have the jurisdiction to continue with the criminal proceeding before it. In law, that is a costly failure, and such failure is an admittance by the respondent. Where a party fails to controvert a deposition by an opponent, the issue not contested is deemed conceded. The court held, adding that the onus was on federal government to prove the legality of the appellant's arrest and return from Kenya, the court said. More so, the court noted that Nigeria is signatory to OAU Convention, which it ratified on April 28, 2022, as well as the Charter of Human and People's Rights, which it said prescribed how a wanted person could be transferred from one country to the other. Now I've come to the end of our today's news. Please do drop by at the comment section and let's know what you've